Hey there. That was one of our little Q&A clips. I hope you found it informative or helpful or just enjoyable. I am attaching a related video that we have put together a while back that is on a similar topic and or an extension of what we were just talking about. So if you needed some more information on that, that's a place to start. You can also look in our playlists. There is a ton of them. I think there's over 1,000 videos. So there's almost every topic in the world touched upon in some way, shape, or form. And again, as a reminder, you can always put in the comments any kind of question you have, even if it's unrelated to this or any other video. I will talk to you later. Carry on.
Okay. Charles Hines. Hey, you. Nice to see you. Of course, they frown on whiplash. It's simply because it is commonly claimed fraudulently in auto accidents. Well, you want to know, it's funny you say that, Charles. I know you're probably remembering the Brady Bunch episode, right? Where Mr. Brady throws a suitcase for the guy. Mrs. Brady gets in a car accident. She's got the kids fighting in the back. She says it's not her fault. Guy says, it was your fault. You hit me, you terrible driver. And they're in court because I guess he sues him for, I think, the property damage, maybe, not necessarily the physical damage to his body that he's claiming or pretending. And he comes in with this big neck brace, and they're like, "Wait a minute, he didn't get hurt, and it wasn't our fault." And all that stuff. And the kids in the back are saying, "I didn't see you look before you crossed the road, or whatever she did, before you pulled out, or whatever, mom." And then it turns out later the kids were fighting in the back, so they were looking anyway. They wouldn't know whether she did. It's pretty funny. And then Mr. Brady, when the guy comes in with the big neck brace, takes his suitcase and throws it really loud on the ground, and the guy turns around and looks at it. And then, of course, they win their case because he just proved that he doesn't have this like frozen neck business. So I worked for the insurance companies that were trying not to pay the people that sued for the whiplash and such. And there was something called tort threshold. If someone did sue in a car accident, this still exists, and they don't have a certain level of damage, provable objective damage, they don't hit the threshold, and they opted for the cheaper insurance that says you have to meet the threshold to sue the other person, then your case would be dismissed. And I used to write all those briefs and get those cases dismissed on summary judgment. But whiplash can be bad. I mean, you don't have to break a bone in your neck to do serious damage. We have ligaments and tendons, right? We have all that stuff. So it can be very serious. It's just that it's very hard to prove. Now, I don't know. Now we have different, technology. When I did the New Jersey work, this was like in the 90s, you know what I mean? So the technology has changed. The medical way to recognize things has changed. There could be EMGs and things that show different things, I think, than before. But again, SSC is pretty picky about, showing nerve root compression, impingement, showing radicular symptoms, which could be shown potentially by an EMG, and nerve conduction studies. If you have canal stenosis, that can be helpful because that means there's a narrowing right there, and your cord could be, there's impingement, there's discs, there's nerves getting impinged upon, and the cord getting impinged, being, compressed or touched. So there's so many things to look for. But yeah, the term whiplash does not really turn a lot of heads, except that guy in the court with Mr. Brady. Oh, that's funny you say that, Charles. I get it.
Hey there. That was one of our little Q&A clips. I hope you found it informative or helpful or just enjoyable. I am attaching a related video that we have put together a while back that is on a similar topic and or an extension of what we were just talking about. So if you needed some more information on that, that's a place to start. You can also look in our playlists. There is a ton of them. I think there's over 1,000 videos. So there's almost every topic in the world touched upon in some way, shape, or form. And again, as a reminder, you can always put in the comments any kind of question you have, even if it's unrelated to this or any other video. I will talk to you later. Carry on. Good afternoon. Okay, we have another circuit case. This is called Littrell versus the commissioner of the SSA. Doesn't really matter which commissioner, guys, because it's always going to be whatever commissioner is currently the commissioner at the time the case is filed. And that doesn't mean the commissioner was even there when the wrong was done, the alleged wrong. Okay, so this is an Eighth Circuit case and it's a remand. So in this case, the claimant, the appellant, who took it all the way from ALJ to appeals council to federal district court up to the circuit court. So lose, 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 boom, win a remand at the circuit level. Eighth Circuit, for those of you not in the Eighth Circuit, these decisions are all really helpful to all of us in every circuit. I do probably every circuit in terms of the lower level. I don't take them to circuit court. I refer anything ever needed to colleagues to see if they'll take it. But all of my cases are probably stretched out in every single circuit since I do national and every state in the country. And again, the circuit court cases, in my opinion, even if it's in a different circuit, can really give you a lot of guidance. And I believe various circuits pay attention to other circuits. All right. This is a summary of this case that I'm going to then paraphrase to a certain extent by Adriana, again, who I always refer to, and I love her shares. She's so good. And she goes on to say, okay, so this is an October 4th, 2024 issued case, and there is a majority decision and there is a dissenting opinion because there was a dissent. So while the remand was obviously the majority and the claimant got to run with that, there was a circuit court judge who dissented and discussed that in a dissenting opinion so we could know why he or she dissented. Okay, so it looks like Littrell was in a SSI case, apparently not a Social Security disability case. As you know, there's SSI and SSD. SSI is Supplemental Security Income. It's a federal welfare program. You did not have to work and pay in for it. If you're under 65, you just have to be disabled and poor enough. SSD or SSDI or SSDIB, as sometimes it's called, is Social Security Disability Insurance Benefits. And that is the ones that all us workers pay into out of every paycheck or through our self-employment taxes. And that's what's get us insured. It's insurance. So if we don't work or we work and we go under the table, we don't pay in, you're not going to have the credits and you're not going to have the Social Security benefits you would otherwise have. And you might be eligible for SSI then if you become disabled and you're poor enough. All right. SSDIB, you do not have to be poor at all. You just have to be disabled and unable to work, SGA, as a general definition. Okay. And as defined by the Social Security laws. All right. I'm going to brighten this up so I can see better. I'm a little blind, as some of you know. Okay, so she appealed the denial of her SSI case, obviously. And she was challenging how her complaints of back and knee pain, which were apparently chronic, and generally that would have to be the case for it to meet even the duration of 12 months, how they were handled. The ALJ, in her case, didn't give enough weight to her pain complaints, she argued, mainly because there wasn't enough objective medical evidence to support them, according to the ALJ. Claimant Littrell felt this was wrong, and so she took the matter to federal district court. After then, the appeals council must have declined to review the case itself. Which bring up another point, guys. If you get denied at ALJ and you take it to appeals council, which has a relatively low remand rate and an even way lower reversal rate, if you have reason to know that there was laws not followed in terms of the evaluation steps that have to take place, and I mean the micro steps, don't hesitate to take it to federal district court. If you find it, there's two ways to do it. You can have a federal district court attorney, and you're not going to have to come out of pocket with any money for that. And if you don't prevail at federal district court, they won't be charging you, as I understand it. You can go that way. Or I have known, well, I would say at least a handful now, personally, that have taken their declined AC cases, appeals council cases, to federal district court themselves. I find that incredibly wonderful. Obviously, that might not be something everybody can do, but I have no reason to believe these people were rocket scientists. I think they were just average people. So if there's a will, there's a way. And if you don't find a federal district court attorney that will take it to federal district court, don't let that stop you. Do a little bit of research. And I think the federal district court really does want to look at what you have to say, but you want to make sure you hone it. I would do some research on federal district court cases and what they're allowed to consider and what they're not. So you're not wasting that bit of attention you're going to get from them when they review on things that they can't consider, like your feelings, for instance, and any disgruntled feelings you have about the system or anything. Keep that stuff out. Hit on exactly what did not happen. And that's going to be what you see in your ALJ denial, because you're not really appealing the appeals council. They just declined to review. You're appealing the ALJ denial, or partially favorable if that's where you're going with it. So this is what Littrell did, one or the other. I assume she had an attorney only because that's more typical. And here's what Adriana shares with us. The Eighth Circuit ruled in Littrell's favor, and the key issue here was the ALJ's dismissal of her subjective pain complaints. Now, we've had a recent other kind of pain circuit court case where the case was not remanded. So it'd be interesting, and maybe I'll do this at a later date, to compare if there are comparable points between these two cases, because it's the same. I know it's a different circuit, but I'm curious to see what the differences are. Since they all generally follow the same rules of the Social Security Administration, but what were they seeing differently? What were the differences in the cases to make two different results? Albeit there was two different circuits. I believe it was not an Eighth Circuit case, that other one, which I think I spoke about recently. So while it's true that the objective medical evidence is important, the Eighth Circuit's noted, it can't be the only factor in deciding whether someone is suffering from pain, as per a prior case called Halverson versus Astro. Astro was a prior commissioner, guys. The majority of the judges felt that the ALJ didn't dig deep enough into Lachelle's pain complaints, and this ultimately led to mistakes in assessing her RFC, residual functional capacity. We have a playlist on that if you don't know what that is, and in questioning the vocational expert about her ability to work. So the court sent the case back for a more thorough review. So that's interesting to know. The decision was not detailed enough, apparently, in assessing her RFC given the pain complaints. And maybe the vocational expert questions were not really honed towards recognizing the pain complaints. So let's go on. We are told that here's where it gets interesting. Thank you, Adriana, for that heads up. The dissent. So she might spend more time on the dissent than on the actual holding, which is kind of interesting. This was by Judge Strass, Stras, who had a different take on things. In his dissent, Strass says, quote, "I would have affirmed the judgment." I guess this isn't going to be detailed. That's it. No argument, no analysis. You can infer the reasons why he would have wanted to affirm the judgment, but that's all he wanted to say. And then Adriana shares her take on this, which again, I appreciate that, Adriana. The ALJ had enough evidence to justify the denial, even if it wasn't perfect. That's what she thinks Judge Strauss is trying to say. Court should generally defer to the ALJ's findings unless there is clear legal error. Now, it's funny, I had a conversation online with somebody who said there should be a greater ability for appeals courts to not defer to the judges that actually had the hearing. I didn't really agree with that because I think our appeals is what actually covers that. But anyway, he'd emphasize that sometimes this is Adriana's take on what Judge Strass would have said if he had detailed his thoughts a little more comprehensively. He'd emphasize that sometimes administrative decisions should be trusted, especially when there's reasonable basis for them. So, she says, Judge Strass's simple, "I would have affirmed the judgment," dissent highlights an ongoing debate in disability cases. And this debate, she says, includes the following. How should subjective pain be weighed? The majority says it needs more attention, but Strass suggests that too much second guessing of administrative decisions could set a tricky precedent. I get both sides. I do. Implications for RFC, residual functional capacity, and vocational expert testimony is this. If the ALJ's evaluation of pain is flawed, then the entire analysis of whether someone can work is compromised. Strass, however, felt the ALJ's findings were sufficient and that Luttrell's pain did not warrant overturning the decision. This case is a great example, she says, of the rather delicate balance between subjective pain and objective evidence. It is a reminder that judges, ALJs, and the attorneys, all of us alike, and I would say pro se people too, need to be mindful of both. And yeah, it is tricky, guys. Subjective pain, and there's been some video talks where we talk about pain is reported subjectively because it's what we feel inside and there's no direct objective evidence. But there is other direct objective evidence that can support the likelihood of the pain being so. We talk about MRIs that show spinal cord impingement or an abutting of the nerve, an exiting nerve from the spine. There are other objective tests. Let's say it's carpal tunnel type of stuff or pain, neuropathies, EMGs, nerve conduction studies. Those are objective tests that show objective nerve activity that would not be consistent with no problems at all. So it's objective. The difficult ones tend to be fibromyalgia, things of that nature, of which they have not yet identified markers, blood markers. That can be objective too. It's difficult with some of these cases. The more you can do to corroborate your subjective pain. Sometimes a diagnosis is the start, but it's not going to be the full 9 yards because so many people have the same diagnoses that we typically see, yet they're still working. They had it for 2 years, then they weren't working. And it's important to, another way, I'd call this a soft evidence thing, but those things can add up to the crumbs to build your cake of a disability award. If you are very proactively seeking pain relief in healthy ways, ideally, but you're going to the doctor for it, like if you are working with the diagnoses and complaining of pain, but then you start, as the pain grows and it's starting to interfere with your quality of life, which would also probably mean you're starting to get worried about being continuing to able to work, getting proactive to find the solutions for the pain or the diagnoses or the ramifications of the diagnoses and the symptoms. The mere fact that you do that is a piece of evidence. I say soft because it may not have produced any direct objective evidence at that point, but it shows a person who is trying. They're complaining at every visit. That's subjective, but they're doing it. They are getting tests done. They are following through with conservative therapies, whatever's offered. They're considering less conservative therapies if those are offered. I just did a video on the Social Security ruling on prescribed treatment, when it can put a fork in your case if you don't follow prescribed or recommended medical treatment for your complaints and your diagnoses, and the ways in which you can mitigate that by showing that you had just cause not to do the prescribed treatment. I would recommend a look-see for that if that fits your boat, since we're talking about right now the helpfulness of showing that you are walking the walk of someone whose life has been altered by a medical impairment, and they're trying to show that it's disabling them and it's changing their life. Usually if something is negatively changing our life, we do something about it. That's going to be the common sense expectation that human nature will do. So if you are complaining, say to your primary care about stuff, and you're not pushing him for a referral, or if he does give you one, you don't follow up with it, it's not going to look good. So while again, those are not necessarily objective pieces of evidence, they are circumstantial, and circumstantial is a huge factor in all sorts of legal cases, not just Social Security disability. It's not going to negate the fact that you need medically acceptable diagnosis, that you are not going to need objective evidence that there is something directly wrong. You still want to get that stuff, but the support that helps show the severity of that pain, so it's not like a dealable pain, can also be aided by the soft evidence. I'll say the soft evidence of that particular kind of circumstantial evidence. The fact that you are trekking out there to get that treatment, or having someone drive you, if that's the case may be, but those visits are showing up, the attempts are showing up, the comprehensive efforts to, if one therapy doesn't work, one recommendation, you're willing to try the next one. That's what people do when they are very troubled by a medical impairment. And not doing it can kind of shed a light, correctly or incorrectly, granted. But let's face it, human beings are looking at your case and making a judgment call, just as you do on people every day. So try to, in my opinion, go for those soft and hard pieces of evidence. And in this case, like I said, the subjective pain Luttrell was feeling was not delved into enough, apparently. I will in time read the case myself. But in the meantime, I love Adriana for putting these out there. I think it's great. And she does such a great job. I respect her immensely. Okay, I'll talk to you guys later. Bye. Hello again. I hope you enjoyed the video. I hope it was helpful, if not just a little bit informative. In the event you have a Social Security question you want addressed, please feel free to make a comment below and ask the question, even if nothing to do with this particular video. And just a quick, again, reminder, we have our daily video shares and tips around noon every day of the week. And on Wednesdays at 1 p.m. Eastern Standard Time, we have our live Q&A session where you can come in live and enter your questions in the chat. And we all pretty much have a good time for an hour or two. I look forward to seeing you there, hopefully. And lastly, don't forget about our benefactor memberships. They're very reasonably priced. The first one is very nominal, and you get a few perks, but on a bigger scale, it contributes to us being able to fulfill a mission of assisting certain people with representation that would otherwise not be able to get it. We look forward to continuing to do that, and so far it's working out like the bomb. So thank you for being here. I appreciate it. Bye-bye now.